Good morning, Miss Lathan. Thank you, Mom, for coming. Appreciate it. Miss Lathan, you're charged with assault of a family member. You're facing up to a year in jail and or a $4,000 fine. We're going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present if you cannot afford one. One will be appointed to you. Okay.
Judge, the complainant reported being assaulted by the defendant, who is the complainant's daughter-in-law, at the defendant's residence in Harris County, Texas. The complainant stated she was at the residence with the defendant for the complainant's son's birthday. The complainant advised she engaged in a verbal altercation with the defendant about the child not saying goodbye. The defendant got into the victim's face and the defendant lunged at the complainant as if the defendant was going to strike her. The complainant stated her son and husband attempted to separate the defendant and the complainant, but the defendant was able to kick the complainant's right breast, causing a high level of pain due to recent breast cancer surgery. The complainant stated the defendant yelled, quote, "I will fuck you up," as she was pulled away. The defendant stated they had a get-together for the defendant's husband. The complainant became upset during that conversation, and the complainant was slamming doors, yelling and getting in the complainant's face, but did not kick the complainant as she was 9 months pregnant. The defendant was identified with a Texas driver's license.
I make a statement, Judge. And so this case was it 6 months later that it was filed? They never spoke to any of the witness. Janitha was present at that time. Terrell, who's a bailiff upstairs, was present at that time, which is Jillian's husband. He didn't want to go through the whole IED deal and give a statement just yet. But I did provide a witness statement from Janitha where she was there. She was 9 months pregnant at the time, Judge. She had her baby a week later. Her mother-in-law did have breast surgery, cancer surgery before on her breast, but she couldn't lift her leg up 3 inches, much less high enough to kick her in the breast. Police officer had none of the information with regards to Janitha being present. Janitha was there. There was the mother and the Terrell and the father holding the two back, I guess, from each other like this. It was split up, and then that was it. 6 months later, charges were filed against Miss Lathan, and that's it. Officers never spoke with anyone, didn't get the other side of the statement. Janitha did provide a witness statement. The court can ask Janitha. We're open to the court asking the questions to Ms. Kimbrough, where she didn't witness anything after it was split up. They went home, I guess, Janitha, and then that was it. There was no physical contact, anything of that nature. Nothing.
Give a response, Mike.
Judge, I haven't read the offense report thus far. I know that this is what the victim has reported. I don't know who the investigator spoke to, but I know this was a delayed report. That's why the 2B warrant was filed.
There was no documented injuries, Judge, no photographs, no nothing. They just on their own volition.
Remember, this is just mere probable cause, right? So, and the fact that, she's pregnant is unable to, I don't know that, right? So all this is a probable cause. It doesn't mean that you're guilty, right? Just it's a mere probable cause. There's still a lot before someone can be found guilty beyond a reasonable doubt. I mean, that's a lot higher standard than what we're just doing today. I am going to find that there's probable cause to go forward. What's the dynamic now? I guess it's 6 months down the road.
I mean, do
they want to have contact?
Do you still have contact with your mother-in-law?
So on Marilyn, is there still contact between you guys?
On and off, not too much.
Okay, so the only thing I'm going to ask is just don't have any threatening or harassing contact with this person. That's all I'm going to ask you to do at this point, okay? I'm not going to put any other conditions in your bond. Just be careful. Don't pick up any new cases. You got a great lawyer. I will waive your appearance. You don't have to waste your time coming to court. Mr. Kamek will tell you when you have to come back to court, and that's all there is to it. Just be nice. Don't pick up any new cases, You guys have any questions?
That's it.
So for now, what I'm going to do is I'm going to have just Michael create the bond conditions. We'll have you sign it, and then you guys are free to go. Just do your thing and just have fun.
Judge, did you set a bond amount?
Oh, Mr. Torres, you're charged with assault of a family member. You are facing a year in jail and or a $4,000 fine. We are going to do probable cause. You have the right to remain silent. Anything you say can or will be used against you. You have the right to have an attorney present. If you cannot afford one, one will be appointed to you, sir.
On October 15th, 2024, officers dispatched to a welfare check at a residence in Harris County, Texas. Officers made contact with the complainant, who was observed to have a fresh, large bump to the back of her head. The complainant was observed to be very scared to speak to law enforcement at the time of their arrival, while the defendant was in the area. The complainant insisted that she wanted to leave the house and get out. The officers made contact with the defendant, who stated that him and the complainant had been dating for about 1 month and had recently had a couple verbal arguments. The defendant stated that he was outside and heard screams coming from inside, and when he came inside, he found the complainant on the floor in the living room and that she had fell from the stepping stool that was in the living room. The defendant stated that the argument never got physical between them, and the officer contacted the witness, who called in the welfare check and stated that he received a message from the complainant of a picture of a firearm. The witness stated that the complainant began sending him audio through WhatsApp, and on the audio, you can hear the complainant say, "Jose, run. He is going over there with a firearm. Run now." The second audio that was sent from the witness, you could hear the complainant telling him, "I was able to take the firearm away from him, but he had a knife. Run." The witness stated he called the complainant and was able to hear a disturbance between the complainant and a male. The complainant tells the witness, "I don't want to die," and the witness then overhears a male yell, "If you call the police, it will get worse." And then that's when the witness heard them arguing, and he can tell the defendant's mouth was then covered and can no longer talk. And then the complainant stated the defendant was upset that her ex-boyfriend was trying to pick her up, so the defendant placed a firearm inside his waist and said he was going to look for her ex-boyfriend, and he left the house. The complainant stated the defendant returned a short period later and continued to argue with her about leaving the house. And when the complainant was exiting the master bedroom and going towards the living room to leave, the defendant pushed her back, causing the complainant to fall to the ground and hitting her head with the floor. The complainant stated she lost consciousness after she fell, but when she woke back up, she was already laying on the bed when the defendant was there pleading that he was sorry and he didn't mean to hurt her. The complainant stated she did feel pain. And that's it, Your Honor.
So it is the pushing and falling on the floor and getting hurt that way. Okay. Mr. Torres, I'm going to find that there's probable cause to go forward with your case. I'm ordering you as a condition of your bond not to have any contact with the complaining witness in this case. Do you understand? You don't understand?
No, not one time.
He said, no, he's not gonna have contact.
Okay. I'm also ordering you not to be in possession of any weapons, no guns. Do you understand?
Yes, sir.
If I find that you have a weapon, if I find that you try to have contact with this person, I'm going to put you in jail and you will not get any more PR bonds. Tell me, are you a United States citizen?
Yes, sir.
You are? I'm entering in what's called a magistrate's order for emergency protection. This is a court order that identifies Yolis Hernandez as a protected individual. You cannot commit family violence or an assault against this person. Commit and act in furtherance of an offense under section 42.072 of the Texas Penal Code, which is the stalking statute. You cannot threaten, harass, use another person to communicate a threat or harassing behavior. You cannot be in possession of a weapon or go within 200 feet of where she lives or where she works. Do you understand? If you violate this court order, the state can and will file an additional charge against you, violation of a protective order, and then it's really bad. Do you understand? If you ever have any questions, Mark can help you and guide you through this. Because you have a lawyer, I will waive your appearance so you don't have to waste your time coming to court, but you must stay in touch with Mr. Metzen. He will tell you if and when you have to come back to court. If he tells me he can't get a hold of you because you're playing games, I will issue a warrant for your arrest. So don't pick up any new cases, no contact and no weapons. That's it. Do you have any questions? Okay. As far as the bond is concerned, we need to take care of that.
Yes.
Do you have any prior criminal history that you guys see? Alex?
I can run his NCIC.
In Texas, no, Your Honor, I don't know. Outside, I doubt anything outside.
Your Honor, I don't see any other criminal history.
Yeah.
Mr. Torres, I'll set your bond at $500 and I will give you a PR bond today. okay? But I will not give you another PR bond. If you pick up a new case or violate these conditions, I'm gonna take that PR bond in a moment's notice. You understand? Okay, my friend. So take a seat. We'll have you sign all the documents, but don't leave until we let you go, okay? All right.
Go ahead.
Okay. You want to do the other gentleman?
Yeah, let's do that.
Is this,
Mr. McDonald, Jonathan McDonald.
all right. So, Mr. McDonald, your lawyer wants me to set you a bond. I don't know anything about you. I've never met you before. I know you're going to tell me it's little bunnies jumping in the woods, but my main concern are two things. Are you a danger to the community? Number one, if you're not, and my other one is, are you going to go back to the jurisdiction you're wanted from? My other main concern is what you're wanted for, because I just don't know. So, Amy, tell us about Mr. McDonald.
Yes, Judge Fletcher. So he's wanted from Faulkner County, Arkansas for a theft by receiving 1,000 to 5,000. It's a felony. He looked at his criminal history and would be opposed to a bond at this time. He had concerns about the danger of the community. In particular, he had in 2024 an arrest that resulted in 7 open charges.
So he had 7 open charges did you say last year?
This year, 2024.
Oh,
Yeah. Felony possession of a firearm by certain persons, driving with license suspended, failure to pay a license fee, theft by receiving, which is separate from this one. And then a fake license plate, possession of controlled substance, and possession of drug paraphernalia. He's also had in 2021 forgery dismissed, felony property dismissed, felony domestic battery 18. He's had a federal firearm charge from 98, federal assault on a postal employee from 99 that ended in probation. And he's had 2 guilty convictions for theft of property and burglary in 88. So at the time, we should be asking for no bond for those reasons.
is he on probation or parole right now? Do you know?
Not that I know of. Dave's gonna come up in a second to tell you for sure, but I don't see that he's on it now.
What's your position?
Judge, we're asking for a bond because it looks like the Faulkner County, Arkansas case, this theft by receiving, it's not violent. Additionally, it was a warrant, so there's no failure to appear or any issues like that. I did,
His 8th charge this year, right?
I wasn't aware of that.
Can I speak?
Yes.
Sure.
Okay, she asked me about being arrested.
Let's not talk about the case.
Okay,
We're talking about my case. My only
Okay.
concern is, I mean, you've got 8 cases this year.
8 cases this year.
may I, to the judge? Okay, Judge. I flew into Arkansas. My mom was dying.
Whoa, let's not have that.
Well, I have to give him some background so you can see what happened. I borrowed my ex's vehicle.
No, let's not just talk about that. Let's just not talk about that.
Okay, well, let me get to it. That's been just, I don't know why that ain't showing up. That's been dismissed. The only thing I've been charged with, the only thing I've agreed to is paraphernalia and her vehicle, not mine, her vehicle. But she's saying, everything.
Is it dismissed? Or out of the 7 charges, what happened?
I'm saying that they're
It was
arrested. Dave
dismissed.
said that they're open charges.
It was dismissed.
Still
open.
That's what Dave said. But I am saying that he was arrested for them.
They're all still open.
The prosecutor dismissed all that gun stuff and all that. My lawyer just contacted me last week. The date where everything was supposed to have been done, they changed it to January 25th. I'm pleading out to the insurance and stuff on the vehicle. It wasn't my vehicle, but I'm pleading out to because I was driving it. And paraphernalia
Okay, so in
That's
January,
it.
you'll be pleading.
to paraphernalia. Yeah,
So
misdemeanor.
all 7 cases are still.
Everything gone. Only thing is,
My concern is that when you have all those open cases, it makes you more of a flight risk.
I've never flee from anything. In fact,
But you're here.
listen, I didn't flee. I never
I
had.
think it was, they filed a new case.
They
He's saying
filed, I
that
was
it
home.
wasn't, he did not flee. It was a warrant.
Is it 2B?
Yes, that's what my client stated.
But what I will tell you, Honor, the conviction she meant in 1999, granted, yes, I did go into federal custody. The judge gave me a self-surrender. They sent me a letter saying, be here at this time and this date. I was there. I got there June 14th, 2 o'clock,
You don't mess with
1999.
the feds.
I didn't come out till 2004. But what I'm trying to tell you is I got sent a letter to come to prison knowing I wouldn't get out for 5 years. I was there. I've never ran from anything. I'm not dangerous. I've never not answered anything. Nothing. You will never find that. I've never escaped anything. In fact, if I just be honest with you, Honor, I don't even really know if you give me a bond, make it. So I'm like, I told her, you know what? I just do the 14 days
So
or
you don't
whatever.
want a bond?
Well, I want one, but at the same time,
Okay, let's
if
just-
it's gonna be
let's-
an
understand.
Can I
big
just
bond.
speak for him? Thank you so
Right,
much.
I'm
I
sorry.
appreciate that. Mr. McDonald also has a couple other background facts that I wanted to make you aware of, Judge. Number one, he does have health issues when he was arrested October 26th. 2 days ago, they took him to Ben Taub. He has a prior heart attack and stents. He says he did get his insulin shot, but he's got some diabetes and high blood pressure issues. So that's just another aspect to consider.
You know, Mr. McDonald, you got to understand this life is so precious. And when you have multiple heart attacks and you're using that kind of dope, you're begging.
Oh,
If you're using any kind of dope,
I've never used drugs.
if you do, you're begging for trouble. So I'm just saying, be careful when you're out there, especially if you have all those health issues. If I were to set you a bond, it would probably be somewhere in the neighborhood of around 5 to 10,000. So that's what it would normally be with these types of fugitive cases, just so you know.
Okay, Judge, I think we'll keep our waiver.
Okay. Hi, Jay.
Days right now.
Happy Monday, man.
Monday, how are you?
Tell me about, this is Mr. Tapia?
Tapia, Johnny.
So just with the, at very little notice, but he's wanted out of New Mexico for 2 counts of aggravated battery of a household member by impeding, interfering communication, and tampering with evidence. Due to the severity of the charges and the amount of charges, is that we would be opposed to a bond. I was also seeing that he was part of a protective order back in October of this year, and it's still current. It's the temporary protective order that's still active for another month, with the, I'm presuming the one for the impeding as a protected party.
So he has 2 open aggravated assault cases by strangulation.
Strangulation or suffocation, interference with communications, battery on a household member, tampering with evidence, with, it says in parentheses, so I'm not really sure how it's, but it says in this verbatim, highest crime, a capital first or second degree felony. And they want no bond in New Mexico.
Yeah, I'm sorry. It's a little bit too much baggage for me, Mr. Tapia. You know, I just, with all those charges, it makes you just too much of a flight risk for me. And it's just too much. It's just too dangerous. I'm sorry.
Even if I were to buy a plane ticket the next day, Your Honor?
Can't take a plane. You've got a warrant for your arrest. You get on a plane, they're gonna arrest you the minute you try to get on. You can't take a plane. You gotta find another way. My concern is that if we let you out, you're not gonna go back. You'll take flight. And that's the main concern. Has he waived yet?
Not yet, Judge.
So the way it works now is if you waive extradition, we give that jurisdiction 14 days to come get you. And if they fail to come get you within that time, then we release you, or Harris County releases you.
So on the 15th day, I would be released.
Again, we talked about that, but again, the law says up to 30 days. Most likely it's 14 days, but except for extenuating circumstances, which we
The law
discussed.
says 30, but we have so many people in Harris County and so many people in jail. As a courtesy, we do 14 days, right? Sometimes, every so often, they'll ask for an extension. I may grant it, I may not. It depends on how much they want, you know. But typically, by and large, it's 14 days. And if they don't come within that time, they file a dismissal and they release you. But you got to understand, even if that happens, the warrant is always there and it will always remain there until you go back and take care of it.
Yes, sir. That's
So-
what I want to do is just take care of it. So
Well, we'll get you there for free here soon.
and is it up to you guys or is it up to Albuquerque to?
It's up to them to actually come and get you. So we reach out to them and let them know, hey, we've got Mr. Tapi here. Can you come get him? And then depending on how many people. Like, is it Albert? You said
Yeah,
Albuquerque?
it's New Mexico. It's Albuquerque.
From New Mexico, you know, they may want to try to get everybody at the same time. So that's where they try to arrange it all at one time. They want to come back and forth because it's thousands of dollars that they're spending just to come get you. You know, it's expensive. It's not cheap. And I'll tell you this too, guys, you know, when you pick up multiple fugitive cases, depending on where jurisdiction you're from, they may try to recover that money from you. So you got to be careful. You don't keep picking these cases up because they're going to charge you.
I didn't even know I had a warrant out. That's, so,
Well, be careful, you know.
yes, sir.
Yeah, okay, guys. What, did you want to waive formal extradition?
I believe that's what I signed, right? I waived it?
The 14 days?
Yes, the
Is
14
that
days.
what you want to do?
Yes, yes.
Okay, guys, we wish you the best of luck, okay?
Thank you, Judge.
Thank you.
All right, gentlemen, you all can go right back through that door again for me. I'll be grabbing this.